Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello, and welcome to podcast number 120. We're closing in another quarter of a century. It's been a fairly eventful 2 weeks for employment lawyers, I think. Obviously, I have to say something about the Unison Fees case. It would simply not be right to ignore what I think is the most significant case for many years in the employment sphere. Secondly, and perhaps more prosaically, we've got a case on territorial rights applying to collective redundancy consultation applicable to offshore employees. And thirdly, we've a cautionary little tale on the perils of disregarding interim injunctions and court orders made in connection with them. Finally, as a reward for you, I'll regale you, if that's the right word, with some of my thoughts on the Wilmad and Wilderness festivals that I was at over the last couple of weekends. As usual, you can access the podcast via iTunes, the Mayor Brown website, YouTube, and the Twitter feed, where the handle is Nicholas Robert, ROBER11. And that's where we have links, of course, to the cases that we have discussed, so well worth subscribing. So, on with the main course, Unison and Lord Chancellor. We simply had to start with this case, I think. To describe it as momentous is probably entirely justified, given that I think it has implications for the relationship between the courts and Parliament that go far beyond employment law. However, we're going to focus on the employment aspects. With apologies to those of you who already know all about this case, let me go through the outcome relatively briefly, and then I'll spend a bit of time talking about what I think the consequences of all this are going to be. The fees regime for employment tribunals in the EAT was introduced in July 2013 and almost immediately ran into legal challenges. The basic idea was that tribunal claims would be divided into two types, Type A claims and Type B claims. To take a case through to a full hearing for a Type A claim would cost £390. For a Type B claim, the full cost was £1,200. There were limited opportunities for the cost of the fees to be remitted or for those on low incomes to be excused paying the fees. As is equally well known, there has been a very significant drop in the number of employment tribunal cases from the point at which fees were introduced. Unison brought a case which they lost at every court before the Supreme Court level, arguing that the effect of the fees order was to deny access to justice and that this was unlawful both as a matter of English common law and as a matter of EU law and the Convention on Human Rights. It was also argued that treating Type B claims, which are predominantly discrimination claims of course, was unlawfully indirectly discriminatory. As we all know, the Supreme Court came down very firmly in favour of Unison and its appeal, and the appeal was allowed unanimously. There were two separate strands to this. First, the Supreme Court, relying on the common law, was very clear that access to justice is a fundamentally important right, going all the way back to the Magna Carta. In light of the fact that it was an idea deeply embedded, if I can put it that way, in constitutional law, the government's impact assessment fell short of the necessary standards. Access to the courts is not solely of benefit to the particular individuals bringing the case. Cases establish legal principles of general importance. It benefits society by becoming part of the common law. Moreover, having a fair judicial system to determine disputes encouraged adherence to employment rights and respect for the law. In the light of this, there was a real risk, looking at the statistics and the costs involved, that parties would effectively be prevented from having access to justice by the fees order. Secondly, it would be futile or irrational to bring a claim in circumstances where the value of the claim was not sufficiently high in comparison to the cost of the fees. On that basis, then, the fees order was unlawful. In any event, the principle underlying the fees order was also flawed. Whilst there was no objection in principle to the idea that the users of the tribunal system should pay the costs, the fees had clearly not been set at the optimal price, given the number of cases which had been driven out of the system. Lower fees, which would have had less of a deterrent effect on people bringing cases, could have been equally effective in transferring the cost burden to users. So on that basis, lower fees should have been imposed. The Supreme Court also considered whether it got to the same conclusion under EU law as it did under common law. Short answer was it was able to come to precisely the same conclusion if it relied on EU law. Supreme Court also decided that although it was not strictly necessary to come to a conclusion on the indirect discrimination claim, because it had already the order had already been declared to be unlawful on the first ground of appeal, and the fees regime had therefore been declared unlawful, the arguments put forward by Unison were preferable. Charging higher fees for Type B claims was not consistent with the aims of the fees order overall. It was not a proportionate means of achieving the relevant aim. Higher fees for Type B claims were not necessarily more effective in transferring the cost of the tribunal system from taxpayers to users. So in the light of this, the tribunal fee system has been scrapped with immediate effect. Tribunals no longer take fees at the point of entry or during the tribunal process. There's also clearly going to need to be some sort of rebate system for claimants who have paid tribunal fees, and presumably as well some account is going to need to be taken of employers who have paid fees too, either at the employment tribunal stage, where they have, for example, been ordered to repay fees having lost the case, or at the EAT stage. And there's no reason to think that employers will be excluded from the right to recover those unlawful payments. All of which raises a number of questions and comments. First, there's been a lot of comment about how the number of employment tribunal claims will now inevitably rise. I would be very surprised if there is in fact not some increase. I would be equally surprised, however, if the numbers went back to the levels seen in 2013 before the fees order was introduced. There's no doubt that employers taking management decisions now, which might be unwelcome to a workforce, are going to have to accept that they are more likely to be sued now than they were a month ago. However, I still think that the ACAS conciliation process, which requires a certificate to be issued ahead of the commencement of a tribunal process, will continue to take significant numbers of cases out of the tribunal system by resolving them by agreement ahead of proceedings being issued. Secondly, the government could look to reintroduce a fee scheme, possibly via primary legislation. I am not sure this is at all likely. Fundamental problem that is, if your rationale for introducing fees is to transfer costs from the taxpayer to the users of the system, employers are users of the system every bit as much as employees are. And I just cannot see a system being put in place where employers are required to pay to defend tribunal cases. I can't see such a system being acceptable to the government. Well, not this government anyway. Let's see. Thirdly, this is a vindication to the benefits to society of having sufficiently powerful trade unions around to act as a counterbalance to employers. If you have a system of employment law, as by and large we do, which consists primarily of individual rights given to individual employees or workers on one side, with employers on the other side, you need checks and balances. Otherwise, the stronger party, the employer, can almost always stack the deck and arrange matters in its own interests. This case could never realistically have been brought by a private individual. Unison fought the case through multiple court hearings, all of which it lost, up to the Supreme Court, where it won, in order to bring about this fundamental change and achieve a resounding victory. If anyone out there still sees unions as a purely negative force holding back employers, this case really ought to give you pause for thought. Finally, if you're a lawyer listening to this, and you occasionally doubt your contribution to wider society in your role at work, reading paragraphs 68 to 73 of the full judgment may convince you that we too have a role to play. So, that's the case of Unison and Lord Chancellor. Let's move on to another case. Seahorse Maritime Limited and Nautilus International. This is another case on territorial jurisdiction, but with a twist. This looks at the right to be consulted ahead of a collective redundancy exercise. As we know, employers have to consult with either elected employee representatives or a recognised trade union if there are 20 more redundancies in an establishment within a 90-day period. Now that's under TALCRA 1992. Now this case looks at the test for what is an establishment and whether the tribunal had jurisdiction to consider the claim where some of the places where the individuals worked were outside the United Kingdom and indeed outside European territorial waters. The Employment Tribunal found in favour of the claimants, so this is an EAT decision on appeal by the employers. The background is fairly straightforward. The company in question is registered in Guernsey. It supplies employees to specialist ships owned by third parties. And I add, because it's important, the third parties are entirely unconnected with the employer. So we're talking about labour supply only arrangements by the employer. The employees themselves come from many parts of the world. The company, which owns the ships, as I say, is unrelated to the employer. People tend to be allocated to ships for a period of time and typically would work 4 to 6 weeks at a time on a particular ship. Ships remain stationary or work, for example, in a particular oil field, e.g. going from Aberdeen to and from locations in the North Sea. Contracts of employment were specifically under English law, and there was a clause saying the parties submitted to the jurisdiction of the English courts. Nautilus, the other party to this litigation, is a recognised trade union. There are a number of redundancies by Seahorse. Nautilus claimed a protective award on behalf of what it described as the UK-based employees who were respondents but not employees who were based outside the UK. The question then was whether each ship was an establishment, in which case the numbers fell below the consultation levels required, the 20 or more redundancies, or whether the employees were to be aggregated, in which case there had been 20 or more redundancies. Secondly, the tribunal also had to consider whether or not there was jurisdiction to consider the claim, given that we were talking about people who weren't working in Great Britain. The EAT upheld the tribunal's decision on both grounds, found the claims could proceed. The issue of whether or not something is an establishment is one that often comes up when you're advising this area, so although it's very fact-specific, it's quite useful to have the EAT's comments here. Whilst it's accepted that ships could be capable of being an establishment, each one of them being a separate establishment, here, of course, the ships weren't owned by the employer in question. The employer was simply providing labour to someone else's ships. Now, this was relevant in deciding that each ship was not a distinct establishment. The EAT also pointed out that in line with earlier case law, if there was a choice logically between deciding whether something was or was not an establishment, and either option was logically available, it was relevant to take into account the option that would be more favourable in terms of protecting employees' rights. There's no evidence to show that Seahorse, for example, organised its business of providing labour into ship-based units, and so in the circumstances the establishment threshold was met when the redundancies were aggregated. Fine. But could the claim proceed at an English tribunal at all? The employers tried to argue that a different test should apply to the collective employment rights under TOCRA than to the individual employment rights under the Employment Rights Act, where, of course, there's been quite a lot of litigation, and we've got quite a clear steer from the Supreme Court, amongst others, in how to apply a jurisdictional test. The test there, of course, is whether there is a sufficiently strong link with Great Britain and British employment law. The EAT rejected the appeal on this point too. This was partly on the basis that although the rights were rights to collective consultation, they were enforced by individuals at the end of the day, because if once a protective award is made, it's up to the individuals, not the union, to enforce it. The fact that the HR1 notification rules, which of course are the rules that sit alongside the collective consultation rules, requiring employers to give advance notice to the relevant government department ahead of any collective redundancies taking place. The fact that those rules have not been amended and still refer to the old test, i.e. excluding employees who ordinarily work outside Great Britain, did not alter the position in relation to the basic collective consultation rights. Overall, I think this is a further development of the law on extraterritorial jurisdiction. Employers may be surprised to learn that employees based outside the UK could be covered by UK collective consultation rights. However, it's important to remember the trigger is only reached where there is consultation affecting employees at a particular establishment. In many cases, it will be possible to show that an employee who is working abroad is working at an establishment abroad, so that the English law claim would be defeated if there weren't 20 redundancies at that site abroad. And by and large, if there were large-scale redundancies at a site abroad, you'd expect that those would probably be covered by the laws of that country, and that the employee in question would be protected or otherwise by that country's laws. So I'm not sure how often this is going to arise, but clearly it's a point to be aware of when considering any collective redundancy exercise, particularly if there are pan-European headcount reductions. Employees who work abroad, such as international commuters, as these were, can be covered by the collective consultation obligations after this case. So that's Seahorse Maritime Limited and Nautilus International. Final case, OCS Group UK Limited and Daddy and others. Sometimes when we're advising clients on the enforcement of restrictive covenants, a client will ask us, what's the sanction if an order for an interim or a final injunction is made, but the defendant breached it? Will an order for delivery up result in the documents being delivered up or destroyed? I'm pleased to say that I think deliberate non-compliance has happened very rarely in any cases with which I've been involved on either side. I haven't seen it on either side either way. But if you want a cautionary tale, if you want a story to tell your clients, especially if they are considering doing something stupid, tell them about this case. It concerns contract cleaning for aircraft at Heathrow Airport. OCS are one of the players in the industry, of course. A rival operation called OmniServe was set up and won a contract start from the 1st of March 2017. As a result, Mr. Daddy's employment transferred over to OmniServe from OCS. Now, it would seem that he obviously had good links with his future employer, because it was alleged that in breach of his obligations to OCS, he transmitted confidential documents and information to home email addresses or external storage devices, and then made use of those documents and information after joining. On his last day of employment with OCS, he was served with an interim injunction requiring him to provide information about items of confidential information he had transmitted to his personal email address or to a third party. It also prohibited him from disclosing to any third party whatsoever the existence of this order. He was prohibited as well from destroying, damaging, deleting, etc. any document which he believed may contain confidential information. So, delivery up, don't tell anyone this order's been made. And there was the usual penal notice warning on the order. Well, the evidence was that, having been served, he broke the no-tipping off rule by phoning one of the other defendants. He also broke it by deleting emails from his phone, and the following day, he deleted about 8,000 emails from his web-based AOL account. Within 4 days after that, however, he confessed to OCS what he'd done, and thereafter he cooperated fully with OCS in seeking to recover the mails which had been deleted. He asserted he'd panicked on the receipt of the injunction, didn't realise the consequences of what he had done until he had taken legal advice. Thereafter, he did do anything he could to cooperate with the claimant. However, by that stage it was too late for AOL to recover the email accounts. OCS applied for an application to commit him for contempt of court because he didn't act in breach of the interim injunction in 4 separate ways, they said. Mr. Daddy pointed out he had cooperated to the fullest extent possible after he realised what he had done. He gave evidence of good character and his family status, looking after his elderly mother, etc., etc. The court, in considering the application, said, well, it could impose a penalty of up to 2 years maximum prison sentence. The object of the penalty for contempt is to punish conduct in defiance of the court order and to hold out the threat of future punishment as a means of securing compliance with the court injunction. Although the court accepted that Mr. Daddy was due considerable credit for having cooperated fully from shortly after his breach, the breach had had a significant effect to the prejudice of OCS because the emails were unlikely ever to be fully recoverable or recoverable at all. Therefore, even though the court accepted that Mr. Daddy had apologised genuinely and wholeheartedly for what he'd done, this did not take away from the fact that it was appropriate to impose a prison sentence on him. He was therefore sentenced to 6 weeks' imprisonment for each of the 4 offences, which were to run concurrently, so he was sentenced to 6 weeks overall. I think this case is, in all seriousness, a useful tale. Mr. Daddy's breaches took place over a 48-hour period or so, it seems, from the case report. Within 2 days after that, he's admitted his breaches in full. He admitted, too, to a number of matters which OCS was entirely unaware of. He didn't contest any of the allegations thereafter. He apologised fully and wholeheartedly to the court and did his very best to undo the damage. He still ended up in prison for 6 weeks. Anyone who is tempted to follow a more deliberate course of action, indeed to cover up what they've done, should be given pause for thought by this case, certainly. So that's the case of OCS Group, UK Limited, and Daddy and others. So there we go, podcast 120. Thank you very much indeed for listening. I said I'd say just a few words about the WOMAD and Wilderness festivals that I went to. WOMAD was the first one, first of the 2. It was great, thoroughly enjoyed it, really good music. 2 highlights, Spooky Men's Chorale, if you've not seen them, they're great fun, they're hugely talented, they're funny, they're also collaborative in that if you go along to see one of their shows, you will get involved in the show one way or another. The other highlight was a band called Ifriqiya Electrique, Ifriqiyya Electrique. I knew nothing about them before I went along to see them. If you imagine a combination of the Velvet Underground and the Jesus and Mary Chain playing world music, you've got some sort of idea of the impact. It was incredibly exciting to watch and quite an experience, really quite an experience. Wilderness music was, to be honest, a bit more hit and miss, but one thing I did really enjoy was I went along to see something called Letters Live, which is generally letters to or from famous people, which can be funny, which can be incredibly moving. Some of them are just beautifully written letters. A whole series of actors and actresses reading them out, from Russell Brand, Benedict Cumberbatch, etc., etc. So if you get a chance to go see Letters Live, I really recommend it. It was the hour and a quarter just passed in a flash, and very moving, very funny, just what you want. Sunday afternoon, great entertainment. So thank you very much indeed for listening. Next week we are going to do a podcast on Australian employment law. We have someone who's going to come along and talk about the differences between Australian employment law and English employment law. And thereafter, there may be a slight interruption while I'm off on holiday for a couple of weeks, and then we'll pick up again in early September as if we've never been away. Okay, thanks very much indeed for listening. Take care, everyone. Bye.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.